It happens even in clubs. It's good to say from the onset that that does not meet the legal standard for consent. It doesn't meet the legal standard. Yes.
Why is that?
Because consent must be informed, you must be informed, it must be specific. And most of the time, it's always required that it has to be recorded. So when you buy a ticket to a conference, they have not told you this other thing about, you know, data collection, uh, what they are going to do with your images. That should be a different thing altogether. You should be coming in at the conference, then they give you separate consent forms. You know, we are collecting this data and we may use them for this purpose. Sign here so that you understand what you are consenting to. So consent cannot be presumed. It cannot be assumed that this person has consented just because they attended a conference or just because they are one of our customers. Yes.
That is morning. Welcome to the Law and Justice Show with me, Tain Jueni, and you are listening to Haki FM, the Oasis of Justice. Thank you so much for tuning in. We are having a conversation about data privacy with Advocate Dickens Ochieng in studio. Keep sending your questions and comments at Haki FM1 on X, Instagram, Facebook, TikTok. We are also streaming live on Facebook and live on TikTok. Wakili, welcome
Yes.
back.
Thank you.
Now, I want us to, while we were going on the break, we said we will come back to talk about employers in terms of data protection. And employers ask for so much information. They ask for your ID, your next of kin details, your bank details, your marital status. They even ask about your medical history. So, how does the law ensure my data is protected in this instance, such that even long after I have left this organization, I am assured that no one will share my data to people that do not supposed to have it?
I think Terry, employers have had, some of the most interesting from the ODPCs, especially from the office of the ODPC. There have been very interesting determinations, especially against employers, on data protection. From what we just spoke about reference checks. There have also been decisions on employers using images of their former employees for promotion. Like, where I work, they may take my pictures and then they may be using it for promotion while I am working at the company. But upon the ceasing of my employment, they should not be using such images, and we have seen such determinations before the office of the ODPC. We have also seen situations where employers have recorded meetings without consent from an employee, and that has cost employers money and even sometimes enforcement notices from the office of the ODPC. So it is true they do process a lot of data, they do process a lot of information from their employees, including health records, marital history, and etc. But data should only be collected for a lawful purpose. So, for example, if the purpose of the data that they are collecting is to ensure that they are paying for your share, you are remitting your payee, and any other statutory obligation, then that would be considered to be lawful. And then the other reason it should be for a legitimate purpose. So if I am collecting data from employees, maybe for the purposes of ensuring that, because I know there are employers who actually engage private insurance companies to insure their employees. So if the reason to collect that data is to maybe submit it or to engage the insurer, then I think that would be a legitimate purpose for collecting information. But that legitimate purpose should not be crossed. So it shouldn't be used in short for a purpose for which it was intended. But there has to be consent. There must be informed consent from the said employee before their data is collected. Yes.
Now, besides employers, how about other employees? Say the HR, say the communications person who will be doing marketing and all those things. What steps should they take to ensure that they protect data of their fellow employees or members, say, of an organization that they work in?
Yes, so number one, I see most organizations, especially for organizations that processes large data, they do what we call data protection impact assessment. So they do impact assessment. How will this data, how will it affect employees? And, can it have a negative effect on their employees, or can it breach the Data Protection Act or the law in Kenya? So many large organizations have been doing data protection impact assessment to ascertain or to identify risks, to prevent a risk, or even to mitigate violation of the Data Protection Act and the right to privacy under Article 31. Then the other thing, especially for communication and marketing team, number one, they need to inform the employee, the said employee, the reason why, the reason and use for those images or those pictures that they are collecting. That is number one. And then HR and the legal department need to know that if an image was collected for promotional services, if the engagement is dependent on the contract of employment, then the moment that employee is out of that organization, then they should no longer be processing that image or information for promotional services. So if I were an employee and they would like to use my image for promotion, and if that use depended on my contract employment, then it means the moment my contract of employment is terminated, then they should actually cease to use that information. Yes.
Does the organization get to hold my information in perpetuity, or does the law provide for how of a timeline for which this organization should hold my information? And if not, how should this information be discarded?
There is what we call the right to be forgotten. And if, for example, today you cease employment anywhere, anybody who ceases employment with an organization, they can actually request for the right to be forgotten. This means that they will be deleting certain information about the former employer, unless there is a law that imposes an obligation on the organization. Because I know there are laws that may impose an obligation on an organization to keep data for 7 years, for example. But then there is also the aspect of proportionality, or minimization of data that should be kept or that should be collected. That is also another important aspect in data collection. So that employers do not go overboard. They do not collect unnecessary data that they don't need. And this is interesting because sometimes in the past, some employees would be discriminated from employment based on their HIV status. We used to have such cases before, and that can only be as a result of the said employer asking the employee to submit their test records or testing them on their premises. And sometimes back while we were student, we also used to hear about it in girls' schools. I don't know if they still do it, where girls were being tested for pregnancy and etc. I don't know if they still do it to date, but that is unlawful. Yes.
And it is interesting that you have mentioned that, Wakili, because now my next question was going to be, when do I know that now you're crossing the line? Say you're an employer and you're asking for certain information during the onboarding process. Where do I tell you that now up to here, now this person is going overboard? And even like you have mentioned, even for schools, up to what point, where do we draw the line when it comes to obtaining data or information from an individual?
So it's not a straightforward thing, but number one, they should inform you the purpose. So, for example, if I say I am the employer and I am collecting data to process payroll and etc., then someone is asking for my HIV status. How is that relevant? So there has to be purpose. They have to state the reason why they are collecting this data. And if you feel that the reason or the purpose for the data collection does not match, the information that they are asking, then you can inform them instantly. Yes, and sometimes in interviews, there are employers who even ask, especially ladies, "Are you married?" Something like that during the interview stage. Those are information that they should not be asking at that stage. Why are they asking? What is the purpose? And that purpose should be in written form. Yes.
Very well. Still on employers, this is a big one because this is where we get the line is very blurry, and that is why maybe we may want to dwell on this a bit. So with the advent of technology, Wakili, there's an increasing use of CCTV cameras, GPS tracking, email monitoring, biometric attendance systems. So where does the law draw the line between legitimate workplace supervision and invasion of employee privacy? And you will get up to things like when people are working from home, they are required to keep their cameras on and so on and so forth. They are being monitored left, right, and center. So again, where do we draw the line between sober monitoring and invasion of privacy?
So that's an interesting question, but it all boils down to consent. So, and the need for the employer to inform the employees that we are actually monitoring your emails, and for this reason, it shouldn't be like an employee is monitoring an employee 24/7 on email, their email systems and etc. There has to be a reason, and they must seek consent from the said employee and actually tell them that we are monitoring your email system because of this reason or XYZ. And that is why I will get back to the example of the recording, the example of the recording complaint that I referred to. So this was a case where the employee and the employer were having a meeting, but the employee objected to recording of that meeting. So the way people have meeting on Teams, and then you say, "I don't want this meeting to be recorded." But the employer recorded, the HR recorded the meeting nonetheless, and they said, and the said record from the meeting was later used as evidence in a proceeding somewhere else. And the employee took the matter to the ODPC, and the ODPC agreed with the employee that indeed, when the employee objected to recording of the meeting, it means they did not consented and there was no reason to record that meeting. That decision would be the same as the email surveillance system and etc. If the employee does not consent to it, then the employer is at risk. They are at risk and they are already violating the law. So the employee should consent to everything, whether it is email surveillance or any other things. Yeah.
What consequences or penalties face these organizations that do not adhere to these rules in terms of data protection?
So number one, the aggrieved person may be awarded compensation, and the compensation is normally paid by the employer. So if an employer, for example, is found to have violated an image right of an employee, they could be awarded some money by the office of the ODPC. That money is normally paid by the employer. So it is a cost to the employer. Number two, there could be a separate fine, and the fine is actually paid to the ODPC. So there may be a separate fine that may be, that the ODPC office of the ODPC may demand from them to pay as a result. There are also enforcement notices where the ODPC sent enforcement notices that asking them to correct, you know, uh, the error or the mistake that they made, if it was a mistake or something like that. Yes. So so let me say it is financially costly to the employer as well.
Yeah.
Yes. And sometimes back, there was a time, there was this issue of this company uh, that was scanning iris, the eyes and
Yes.
etc.
Yes,
And
yes.
they had to stop the operation in
WorldCoin.
Kenya.
It was
Yeah,
called
the WorldCoin.
WorldCoin.
So they
Yeah.
had to stop the operations in Kenya. Yes, after that. So sometimes it's also costly to the employer. Yes.
Yeah. And now I want to shift gears, Wakili, to something that has been doing rounds on social media. If you are on X, maybe you are familiar, whereby, and we've seen this a lot, especially with people who are social media, what do I call them? Do I call them content creators, or they are famous on social media, whereby we get information that their intimate videos were leaked to the public. So is it legal to leak such information, and what are the consequences, if at all it is not legal, of leaking such information about a person?
So number one, I wish to state unequivocally that it is actually unlawful to leak such private intimacy videos on the internet. Article 31, the right to privacy, protects that, and of course there are other laws, including the Computer Misuse and Cybercrime Act, that has criminal penalties for that. So it is important to state from the onset that it is actually unlawful and it violates the right to privacy under 31, the not to disclose private affairs or even family affairs on any platform, whether social media, whether it's Instagram or TikTok or etc. So it's actually legal. So the challenge is, because the way social media is designed, it is very difficult to trace the person who actually leaked it. Is because the moment a post is shared, it would have been reshared almost a million times or 100,000 times. So it becomes very difficult to trace the person who did that. But I believe the law enforcement have the resources, our law enforcement agencies have the resources to actually track people who do that. Only that our law enforcement agencies do not take such issues seriously. I don't know why. Yes, but they have the means and the resources to do that. Yes.
So, Wakili, are we saying that even if I reshare that video, then the only person who is liable is the first person who shared that video on the internet?
So that is where the problem is, because that is where the law is gray. So do you actually pin down the person who leaked the video, the original person who leaked the video, the person who
Right.
reshared it?
Yeah.
But we have seen people arrested in other jurisdictions, for even in Kenya, for resharing photos, videos and etc. But that is where the law is gray. So do you pin down the person who originally shared the video, or just someone on X, a random person who has seen something on the trend, and they say, let me also repost this to my to my wall, something like that. Yes.
And you've said that this attracts criminal penalties.
Yes.
Will you elaborate on that? Because maybe people do these things that they don't even know. They are ignorant of the consequences that they are likely to face. So maybe you can shed light on what are these consequences that they are likely to face.
So when you have been found to have shared on social media, somebody's intimate photos and etc. or videos and etc., you may actually be charged under the Computer Misuse and Cybercrime Act. And that is a criminal offense for which there is a fine and there is an imprisonment. I will have to confirm how many years, but it's actually something that can put someone in prison. Yes.
Okay. Let's talk about now how do I report? Say my videos have been leaked online. What is the next step that I should take? I hear you mentioning a lot about the ODPC. Can someone walk in and report a data breach? What are the steps and what is the whole process? Take us through the process from beginning to end, from how do I report, where do I report, what actions do they take to investigate, and how do these people who have violated these rights end up facing consequences, so to speak?
Yes, so the ODPC is actually an appropriate forum because they have the powers to investigate, not only to investigate, but to also recommend criminal prosecution where somebody is found to have committed a criminal offense. So, number one, if there is a data breach, which you think is, if you think there's a data breach, the first step is to file a complaint to the ODPC. There is a website there at the ODPC. Anybody can actually file a complaint at the office of the ODPC website. Just type in what happened, where, how do you feel your data has been breached. Then they will receive your complaint. They will confirm your complaint via email. They will investigate. They will investigate whether it's an organization or an individual. They will investigate and they can make recommendations. If it's a criminal offense, they can make recommendation to the ODPP, the Office of the Director of Public Prosecutions, to prosecute the said individual or the said institution if it's a criminal offense. If they think that someone should be awarded some damages, then they will award damages against the other party. They may also fine the party or even issue enforcement notices for the mistakes to be corrected. So if someone, violated an image right, or they were using it for promotional purposes, they may be asked to take it down. But also for others that border the cybercrime, data misuse, and etc., it's important that the person also reports to the police station, take an OB, so that this matter be investigated, so that the file can move very fast. Yes.
Could you give an example of such?
So, like, if someone leaked somebody's intimate videos, I think the first step is to report to the police station for investigation. So the DCI can investigate this very quickly. Yes, they have the resources and the means. Yes.
So let me ask you, Akili, does the burden of proof lie with me or with the ODPC?
So if you have you see, if you report to the police or the ODPC, the case is normally the Republic versus the other individual that you are complaining against. So actually, many people should be able to come out to report these things to the police, because the worst that they can be is a witness. But the burden of proof lies with the ODPC. So it's not you, the victim. Yes. So the best that you can be, or the worst that you can be, is to be a witness, testify on your case.
Yeah.
Yes, but the burden of proof lies with the office of the ODPC. Criminal cases are normally Republic versus XYZ, which the person that you are complaining against. Yes. So it's not you versus the other person. And even for the ODPC, if you think your former employer has violated your rights, the moment you submit your documents to the ODPC, it is for them to investigate. They will not even ask you. They will maybe they will ask you to provide additional documentation, but they will not ask you to come and testify and etc. It's them for investigate. It's actually them to reach out to the other party and to investigate and to make a determination. Yes.
There are instances where you attend, let's say, a conference or a seminar, and in the building there's a tag written that being in this room means you have consented to your photos and videos being used. I have even seen events that as soon as you buy the tickets, you're told, having agreed to come to our event means that you have consented to us taking your photos and videos. So my question is this really legal? Is this right? And does that can that one pass as consent?
It happens even in clubs. It's good to say from the onset that that does not meet the legal standard for consent. It doesn't meet the legal standard. Yes.
Why is that?
Because consent must be informed. You must be informed. It must be specific. And most of the time, it's always required that it has to be recorded. So when you buy a ticket to a conference, they have not told you this other thing about, data collection, what they are going to do with your images. That should be a different thing altogether. You should be coming in at the conference, then they give you separate consent forms. We are collecting this data and we may use them for this purpose. Sign here so that you understand what you are consenting to. So consent cannot be presumed. It cannot be assumed that this person has consented just because they attended a conference or just because they are one of our customers. Yes.
That is interesting to know, and I know most people do not know that. They just
I've seen people who have actually come out. They have filed complaints at the ODPC against clubs, and they've been awarded a substantial sum of money.
Really?
200,000, 500,000, because the club took their photos and used them for promotion without obtaining their consent. Yes. Just because they were there at the club and there is a CCTV or the images, people were taking photos and etc. People have been awarded money in damages.
Yeah.
Yes.
So presence is not.